Welcome back to the Incites podcast hosted by the UNSW Law Society. We're your hosts for this episode, Adrika and Will.
Before we begin, I would like to acknowledge the Gadigal people, the traditional custodians of the land in which this podcast is recorded, and pay my respects to their elders past, present, and emerging.
And we are very excited for this episode where you'll be working with HFW.
So in this episode, we're talking with two very special guests. Our first guest is Jo Delaney, our partner at HFW and also a UNSW alumnus. Jo completed her Bachelor of Arts and Law here in Sydney and was awarded a UNSW Alumni Award for organising the first Model UN Conference in Australia. Jo also worked for Sir Anthony Mason as his research assistant after retiring as Chief Justice of Australia, before moving across the world to complete her Masters of Law at the University of Cambridge. She spent over a decade in London and has since returned to practice over a diverse range of industries in Australia and overseas. Jo specialises in complex dispute resolution with a focus on cross-border matters in the Asia-Pacific region, which we look forward to exploring with her. Notably, Jo was also one of Australia's two members to the ICC Court of Arbitration from 2018 to 2024, and is chair of the ACICA Professional Advisory Committee, a director of the ACICA Practice and Procedures Board, and co-chair of the ERA Pledge APAC Steering Committee, and a member of the ILA Management Committee.
We'll also be joined by Nivi Venkatraman, who is a senior associate in the construction group at HFW. Nivi completed her Bachelor's of Commerce and Law honours at ANU, followed by her Master's of Law at USyd. She has since worked in both domestic and international commercial dispute resolution, with experience in building, construction, fraud and insolvency, renewables, property shareholding, trademark infringement enforcement, and general contractual disputes. Nivi worked at the Asian International Arbitration Centre in Kuala Lumpur for 4 years before joining HFW in 2022. Last year, Nivi was also elected by the ICC Arbitration as an ICC YAAF representative for South Asia for the 2024 to 2026 mandate.
Great. So to start off with, for our listeners to get a bit of sense about who you guys are, we'll start with a few icebreakers. So first question I want to ask you guys is, what is something new that you've learned recently, which is totally unrelated to the work that you guys do?
Thanks, Will. Thanks, Andrika, for having us. We're very excited to be part of the podcast today. Asking us about something new that we've learned outside the law is quite tricky, particularly for two working mums. It's very difficult to find spare time other than following your children's interests. So for me, two things I've learned that are new are, one, I've learned a lot about cricket since my eldest son is obsessed with cricket. My husband is also obsessed with cricket, and I found it a lot easier to go with the flow and learn about cricket and watch cricket with them. So over the last 18 years, I've learned a lot about cricket. The second son is obsessed with dinosaurs, so I've also learned a lot about dinosaurs, and we've been on many dinosaur trips looking for other fossils in different parts of Australia and also in England, and we've also looked for dinosaur footprints in Australia.
Have you found any?
Yes, there are plenty of dinosaur footprints down on the coast near Apollo Bay in Victoria.
Wow. What about you, Nivi?
Well, thank you both for having me on your podcast today. So I've been on maternity leave for a while now, so I finally found the time to start reformer Pilates classes, which has been fun. And I think I finally understand what people mean by it looks easy, but you feel the burn.
Oh, that's great. For the next question, if you could instantly master an area of law outside of your current practice, what would it be and why? I'm very interested in this one.
For me, I think it would be climate change law and international environmental law. So I do support some of our experts in our office who do climate change law, and I've supported them with different types of disputes relating to carbon markets. We also do a lot of construction disputes relating to energy transition projects, but I don't really have that in-depth knowledge of climate change that they have, and I would really would like to have that.
And I think for me, something that doesn't really relate to my area of practice, but I'm interested in, is tech law, because I think that the technology space is rapidly evolving and it's so ingrained in our day-to-day lives. And we've also got IA taking over pretty much everything we do in the legal industry as well as our day-to-day lives. So I think it would be interesting to be at the forefront of change and help clients in that sector navigate all their legal issues.
Yeah, that's really interesting.
Yeah, and our last question. So if you guys weren't a lawyer, what do you think you'd be doing right now?
That's also a surprisingly hard question because you may start uni doing a law degree because you're interested you might be interested in history, you might be interested in international relations, and law sort of goes quite nicely with that. But then once you start practicing as a lawyer, well, at least in my case, I do really enjoy it. And I do often ask myself that question, particularly late at night or on weekends when I'm still working. And I do really love what I do. So I love doing international types of cases, as we'll talk about. If I wasn't doing law, maybe I would have done music. I played music at a high level at uni and decided to do law rather than music. But to be honest, I don't think I would enjoy it as much as I enjoy the law.
That's great. What about you, Nivi?
Well, I think as a child, I was always fascinated by spy thrillers and crime fiction. So I'd like to think that if I didn't do law, I might have become a detective or done some sort of intelligence analyst kind of role.
That's very interesting. So many of our listeners are our student base, and a lot of them might not be too familiar with what international arbitration more generally is, what work you guys actually do. So the question I have for you both is, if you had to explain your role just to a child, not using any complex legal jargon, how would you go about that?
Well, I hope this is not too simplistic, but if international arbitration relates to resolving disputes. So if two people argue, they could be arguing about anything relating to a construction project. They could be arguing about, probably the simplest type of dispute we see is the buying and selling of goods. So they could simply be arguing about who is going to pay for the goods, and it may be that, for example, the seller is saying that they have not been paid for the goods, and the buyer is saying we're not going to pay for the goods because they're not the right goods or they're not of the right quality. So the two parties are arguing, just like kids would argue with their brothers and sisters, and instead of mum and dad interfering, it would be a third party decision maker. So typically in the past, this type of dispute would go to the courts and it would be decided by a judge. But over time, international arbitration has developed to deal with international disputes. So disputes between two parties that come from different countries or different nationalities. And so, for example, if you had an Australian seller and an Indian buyer, it may be that the Indian party does not want to go to the courts in Australia and the Australian party does not want to go to the courts in India. So they agree to go to arbitration, and the arbitration is seated in a neutral venue, which is Singapore. The parties also get to choose who is the decision maker, who is the arbitrator of the dispute. And so the parties will then choose the arbitrator. If they can't agree on an arbitrator, there is a body or an institution that will appoint the arbitrator for them. Once you get a decision from the arbitrator, there is also a process for enforcing that award, which is if one of the party does not pay. So say, for example, the Indian party says, I'm not paying for the goods because they weren't the right kind or they're not the right quality. The arbitrator decides that they were of the right quality and you need to pay. They don't pay, so then you can go to the courts in India and enforce that award under the New York Convention on the Enforcement and Recognition of Foreign Arbitral Awards. And so this process has been set up to deal with international transactions, international projects, and to help to facilitate the global economy. And through that process, parties are able to get a resolution of their disputes outside the court system.
Thanks for that, Jo. I think that really broke down arbitration for our listeners and definitely for us as well.
So kind of following on from that, a lot of our students probably have a lot of conceptions about what international arbitration kind of looks like and what you guys do. So are there any common misconceptions that you guys would like to debunk? Is there anything that students have said to you guys about international arbitration that you'd like to clear up?
Well, I think one thing that I frequently hear is that arbitration is quick and cheap. And I think that really depends on each particular case, because sometimes it can be just as expensive or as drawn out as a litigation matter. And I think the other thing to keep in mind is also that there's a misconception that once you have the final award, there's no recourse in terms of trying to set aside that award, and that's not true. There are some limited grounds where awards can be set aside, but these eventually turn on procedural considerations. So you're looking at breach of natural justice issues or public policy concerns in terms of having that award set aside, rather than engaging in any sort of merits review of the decision.
I could also add that another misconception is that arbitration is just like the court process, and it's supposed to be quite different. It's a much less formal process. We don't have court procedural rules. We don't have the evidence rules that apply in a litigation. So it's very much up to the parties to determine their process, and they don't need to follow the court process to do that. The tribunal and the parties can come up with a process that is more efficient for that specific type of dispute. So they would usually set up the procedural timetable up front. That would include all the steps in an arbitration process, like filing your statement of claim, filing a statement of defence, filing your evidence, filing expert reports, preparing for a hearing, and the hearing dates would all be set out in that first procedural timetable in procedural order number 1. Once you've got that procedural timetable, the parties just follow that process. That process can be very efficient and streamlined. Sometimes parties will come back to the tribunal with a specific issue, like an argument about the disclosure of documents, but often they won't. So that's something that is probably a misconception, is that you can actually run the process like that rather than just like court proceedings where you've got directions hearings all the way through.
That's so interesting. I think that's definitely a misconception I had about the area. So on to, I guess, a bit more about your own journeys to where you are today. We'll start with you, Joe. I know you worked for a number of years in London. You studied there as well. I'm interested about what drew you to international arbitration and also what brought you back to Australia.
So I was looking to practice public international law. That was my passion when I was a student, but I didn't know how I wanted to practice it. So I worked as a research assistant to Professor Rosemary Rayfuse when I was a student, and so I saw a little bit about what it was like to be an academic. I worked as an intern at the United Nations Human Rights Centre in Geneva after I finished law school, and spent 3 months doing that, and decided it was interesting to see it from a policy perspective, but it may not be right for me. So then I tried being in a law firm and worked on cases, which I enjoyed. I also did the Jessup Moot, and I really enjoyed working on cases. So when I went to do my master's at Cambridge, I came across one subject, the peaceful settlement of international disputes, which was taught by Professor Vaughan Lowe. And in that course, he taught about arbitration. So state-to-state arbitration, investment treaty arbitration, and commercial arbitration. And in my last lecture, one of the partners from Clifford Chance, Audley Shepherd, came to speak to us about commercial arbitration. And I asked him about working in that area. Turns out they needed people in their group at the time. So I interviewed. I was very fortunate to join them a month or so later. And then that was that. I spent 13 years with them working in arbitration. So the first few cases I worked on were commercial and construction arbitration, but very quickly we got an investment treaty case, and that was the first one that the firm did at the time. We acted for the Czech Republic in 2 parallel cases, and it took about 5 years for those cases to be resolved. So that sort of confirmed my decision as well, that arbitration was my area. And whilst I loved public international law, what I really loved was cross-border disputes and trying to figure out how to do that. So then what brought us back to Australia? Probably family. You're away from family a long time. My family was here. My husband's family is in India. So we decided we'd move back to Australia. The work was getting more interesting in the arbitration space, more and more arbitration work in Australia than there had been in the 10 or 20 years before. There's even more work in arbitration now than there used to be. So that makes it possible to be an arbitration lawyer in Australia. And now we're seeing many more arbitration lawyers coming back. It's obviously also a great place to bring up your kids. So we're really pleased that we moved.
Yeah, that's amazing. And it seems like you kind of had your heart set on arbitration from university, which is really cool to see. So, Divi, I understand you've worked some time in commercial litigation and disputes and also in the arbitration sphere as well. Was that always your goal? We hear lawyers sometimes say they fell into a specific practice area. So how was your journey into arbitration?
So I definitely fell into the practice area. So when I left law school, I was actually not certain if I wanted to be a lawyer, but what I was passionate about was insolvency. So I actually started my career working for insolvency practitioners, so on the accounting side of insolvency. So I worked with liquidators and trustees in bankruptcies, administering bankruptcies, liquidations, voluntary administrations and receiverships. And while I was in that role, I also gained exposure to working on some litigation matters that related to recovering voidable transaction claims. And that made me interested in, trying out to be a lawyer and to see if I could actually do well as an insolvency lawyer. So then I jumped ship, got admitted, and I started my career at a national law firm within their commercial disputes and insolvency team. And when I was there, I thought I'd be mainly doing insolvency work, but lo and behold, they sent me on secondment to a government department to do FOI and litigation work. And within my first week there, I found myself appearing before what was then known as the Administrative Appeals Tribunal, arguing a case on behalf of this government department. And I'd never even done a directions hearing before that, so that was nerve-wracking. But I think the adrenaline rush that I had preparing for that case and presenting the oral arguments made it clear to me that a career in disputes is what I was interested in. Over time, I ended up doing a master's degree, and I did a course on international arbitration as part of that degree. I didn't have any exposure to international arbitration before that, so that opened up a whole new world of opportunities for me, because I finally realised that I could have a disputes career outside of Australia that would be portable internationally. Due to personal circumstances, at one point in time I moved to Malaysia to be with my husband, and I found I couldn't practice law in Malaysia, so I had to look at an alternate career path. And that was when I applied to be an intern at the Asian International Arbitration Centre. And I initially started being engaged by the AIC to work on a book on arbitration in Malaysia. So I never thought I'd ever work as a researcher on a book before. So that was fascinating. And from there, I ended up getting a permanent role at the AIAC, and I became an international case counsel, which led me to actually get involved more with the arbitral institution, administering a large number of cases, mainly relating to construction arbitration disputes. And I was also actively involved in a lot of the capacity building initiatives and organising events and conferences and writing a lot of articles. And I think that cemented my interest in international arbitration. Through my work at the IOC, I also met Joe. And over time, I decided that I wanted to come back into private practice, which brought me to where I am now at HFW.
Wow, that's a really remarkable journey through a lot of different areas, and I think it really speaks to the fact that although you might have a plan, both of you, law can really take you anywhere depending on who you fall in with or who you meet.
There's actually a lot of UNSW alumni working in international arbitration overseas, so I thought that students might be interested in that. So I hope I've not forgotten any key people, but just a couple of people that I thought of. Tim Nelson was an alumni of UNSW, and he's a partner at Scaddons working in New York and London. Judith Levine is the AKICA president, and she's an independent arbitrator. She worked at the Permanent Court of Arbitration in The Hague, and she also worked at White & Case in New York after doing her master's in New York. Anna Stanek was at university with me, and she set up her own law firm in London, E&A Law, and she works across all of Europe, particularly Eastern Europe, in energy law. And then Jennifer Yunan is at A&O Sherman in Paris. She's a partner there, and she's one of the current members on the ICC Court of Arbitration, along with Mark Mangan. And another alumni, Damien Sturzaker, did his master's at UNSW and has been teaching international arbitration law there for many, many years.
A lot of UNSW alumni.
As we were speaking about sort of falling into the practice, is there anything that you found unexpected or that surprised you during your early careers in dispute resolution and arbitration?
I think for me, and particularly as a young student coming from Australia, where we sometimes feel a little bit isolated from the rest of the world, and it depends on to what extent you're into global affairs or international relations, I found it really fascinating to be much closer and be part of the global economy. And this comes out in the types of cases we work on. So, for example, the first construction case I worked on when I first arrived in London was a LNG project in Oman, and there was a problem with the construction of the jetty. And we were acting for a Japanese and English contractor, JV contractor, in that dispute. later on, in a couple of years later, we were acting in a dispute relating to an Indian power plant that was not in operation, and that led to an investment treaty dispute and a bunch of commercial disputes. But the LNG for that power plant was coming from the same Oman project that we had worked on many years before. So it's really fascinating how the global economy does connect up. And we saw during COVID and since COVID all the supply chain issues that arose. Now we're seeing with tariffs the impact on supply chain, the impact on companies, and that's going to lead to more commercial disputes. So it's really fascinating to see how we can play a role in helping companies resolve those disputes, whether we're actually going through an arbitration process or whether we're just helping them with a strategy to resolve the disputes and find a better commercial outcome for them. I just find that fascinating, that how it all gets connected together.
Yeah, that is very interesting, of course. And Nivi, do you have anything?
I think the one thing that took me by surprise was just how many events and networking opportunities are actually out there that you can actually participate in as a young lawyer. I think sometimes when you're a young practitioner, you kind of get intimidated approaching partners or senior lawyers or people who you look up to as superstars. But when you attend these sort of events, you actually realize that everyone's pretty down to earth and very approachable. And it's very easy to expand your network and also meet people who are just at your level as well in other countries and learn about their experiences. And you find that you have a lot of commonality with people all around the globe who practice within this area.
Yeah, that's really interesting, and I think that's a really good point about networking and building networks early on as well, and just not being afraid to reach out to people as well. So I guess following on from that, what would you guys say is the most valuable piece of advice that you'd like to give a young lawyer or someone starting out in their law career? What could they do to really progress and make the most of a career in law?
I think it goes with the same point that Nivi just made. Networking is probably really important. I think it's taken for granted that as a young lawyer you have to be proactive, you have to work hard, you have to get the job done. And sometimes whilst we're getting the job done, we get a bit lost in that, and of course you have to do it, and you would never do anything that to jeopardize getting the job done and meeting a deadline. But at the same time, and I feel I didn't do enough of this when I was a junior lawyer, and I think many of us at the time it was quite different because BD and networking wasn't as important as it is now. And so I think getting out there, meeting people, not being too shy to reach out to people. I still get shy sometimes about reaching out to more senior people, but don't be shy about doing it. Just ask them for a coffee or walk up to them in a conference and say hello. Whether or not you get to have the coffee, whether or not they respond to your email, it doesn't matter. Just ignore it. Ignore it if you don't get a response, if you don't get a refusal, take it on the chin and ask the next person. But I would definitely say networking is really, really important.
And I think the other thing also, and Joe touched on this, is investing in business development activities. So even as a student or a young lawyer, there are lots of ways that you can be proactive in engaging in business development activities. So, you can go out there and, write a case note on an arbitration-related case and get it published on Clura Arbitration blog. You can get involved in young members groups. You can try getting on steering committees at arbitral institutions and their young members bodies and, help with meeting people in your local community and organising events. So there are lots of ways to actually get more involved and build your own personal profile even from a very young age, but also help grow your firm's presence within that sector as well.
Yeah, I think that's some really valuable advice. We've touched on this already a little bit, but to be a bit more specific, could you both give us a bit of an overview of exactly what it is that you do at HFW and what your sort of day-to-day looks like?
So HFW is slightly different as a law firm. It's structured slightly differently. HFW is focused on industry sector groups. So most law firms are structured so that you sit in a practice area like dispute resolution or mergers and acquisitions or property or employment. We're set up so that we sit via industry groups. So we have a shipping group, a commodities group, a construction group, energy and resources. And that means for us, we sit in the construction team We do construction disputes, whether they go to litigation or arbitration, and we do a lot of those go to arbitration. We also, though, do other commercial disputes because we don't have a separate dispute resolution group. There are people within the commodities group and within the construction group that do general commercial disputes. And so both Nivi and I have experience in commercial disputes, and we'll do those whether they're litigation or arbitration. And we've done all types of disputes, running from property disputes to bubble tea disputes. And we also do investment treaty disputes. So we, as I mentioned earlier, one of the first cases I did in London was acting for the Czech Republic in an investment treaty dispute. I continued doing those types of cases whilst I was in London, and I've continued advising on those cases since I've been back in Australia.
And in terms of what we actually do as day-to-day as disputes lawyers, in the early stage of any dispute, a lot of our work is advisory. So we'll meet with clients, get an understanding of their business and their issue, and provide strategic advice on how to move forward with resolving the dispute, or provide litigation or arbitration strategy advice as well. And then in terms of the actual proceeding, we're all heavily involved in drafting pleadings, or in arbitration that we use memorials, which is basically like a narrative form of pleading out your case. And we also meet with witnesses, prepare witness statements and affidavits. We work closely with counsel to develop strategy, and both for the overall case progression as well as the conduct of hearings. We also do a lot of discovery work during the evidence phase of the matter, and obviously there's a high element of liaising with clients and communicating effectively with clients as well.
Yeah, that's really insightful, and thanks for giving us an insight into what you guys' kind of day looks like as well. We've already kind of touched on this as well, but if you guys were to say one aspect about your practice area that you really, really love, what would you say is your favourite part of being in litigations and disputes?
The variety in the work that we do is something I love. There's no one day that's the same. And I think also the cross-border element definitely is really exciting. I feel like whenever you work across borders, there's always the opportunity to learn about other cultures and legal traditions. And it's just very eye-opening to see how people carry out their business in different parts of the world.
I would also say the variety of the disputes. So is the one great thing about being a dispute resolution lawyer is that you do disputes in all sorts of areas. So I mentioned bubble tea. We've done a franchise dispute in bubble tea. I've learned about traffic modelling. I've learned all sorts of engineering. I've learned about the carbon credit markets to some degree, just different types of disputes. And that's what keeps it really, really interesting and challenges you intellectually. So we might not have that much time for new things outside the work, but we're always being challenged intellectually to learn new areas of the law or new areas of other disciplines.
Mm-hmm. And with all that variety, I'm quite curious, are there any skills particularly that you think are valuable for lawyers that are practicing in such diverse types of cases? Of course, you'd need skills that are quite transferable between these matters.
I'd say on the soft skills side, the most important thing is to be proactive and determined and to keep trying. So to really have a growth mindset, or the concept that you're not going to get it right the first time and that it's always a learning process. So I think that's probably the most important thing, is that just be prepared to keep learning and keep trying, because at all levels, there's more to learn. So that's really, really important. On the technical skills, I would say one of the most important skills is written advocacy. So really, really important to think about how you draft something, and it could be any type of drafting. It could be drafting a letter. It's really important how we draft letters. We might be drafting a letter to the solicitors on the other side, or we might be drafting a letter for our clients to send to their counterpart. Often even those letters involve advocacy and persuasion, because you're trying to persuade the other side of a specific point. Writing a memo, trying to explain your position or the outcome of your research to a partner is really, really important, because that will often then get passed on to a client. And then thirdly, writing the pleadings or the memorials that Nivi mentioned is really, really important, because in an arbitration specifically, much more is written down before you get to a hearing. It keeps the hearing shorter, but it does mean that written advocacy is really, really important.
That's quite interesting. Yeah. What about you, Nivi?
And I think the other thing that goes without saying is that disputes is a high pressure environment. So I think being thick-skinned and being resilient and persevering are really important, because sometimes it really feels like everything around you is falling apart and you really just need to stay strong and work with your team to reach your end goal. And that's probably easier said than done.
Be patient. Yes, be very patient. You need to be patient with the person you're working with, with your partner, who will have multiple stresses. You need to be patient with the clients who also have multiple stresses, because it might be managing people up and downstream, and so they might be managing the project team, and they may also be managing the people that they report to. So, and you're trying to give them information they need to be able to do their job. So being patient is really important. And then just amongst all of that, you suddenly receive a letter from the other side that's might be slightly more aggressive than it needs to be. And so you need to be patient and remember that the letter is not addressed to you personally, and just try and take it with a grain of salt and focus on the real issues, and talk to your client about what you're going to do next.
And also being in disputes, most often than not, you're working on more than one case. So I think being able to work out how to manage priorities, how to communicate both upwards and downwards so that everyone knows what's on your plate and what you're working on. And also having that ability to just stay on top of deadlines is also crucial to being a good disputes lawyer.
I guess all that stress makes the actual resolution all that more sweeter.
Yes.
Yeah, that's really insightful, and I think all the stuff about the soft skills is super important as well, being patient, being proactive as well. So kind of following on from that, how does HFW specifically help, I guess, young lawyers or any lawyers in their journey really develop those kind of skills and the technical skills as well, the soft side?
So the firms, all the firms will provide some sort of training, soft skills training, technical skills training to young lawyers as they come through, and we do some of that as well. I think what's more important though is working and learning that from the people you work with. And one of the benefits or the difference with HFW is that we are a smaller firm. We still do high profile work. So for example, in the construction space, we are still often working on big construction disputes in litigation or arbitration that firms on the other side might be Cause or Clayton Hughes that have very large teams. And sometimes if you're in a large team, it depends on the firm, of course, but sometimes when you're in a large team, you might just be contributing a small amount to progressing the case. But at HFW, we tend to be smaller teams, so you might be playing a slightly bigger role in contributing to the case. And so developing those skills on the ground or on the job is really, really important. So it's not that different, I suppose, to some sort of apprenticeship and how people used to learn. And it's really important that the partners then either impart their knowledge, impart their soft skills, not just the partners, but also the senior lawyers in the team impart their knowledge and impart their skills. And so I'd say that at HFW, the way we would teach lawyers is much more on the job and giving you more responsibility than you may get at some of the other firms.
Yeah, nothing beats on-the-job experience.
Exactly.
Nivi, what about you?
And I think tied to that is that I can say hands down that all the partners I've worked with at HFW have been incredibly supportive and very generous with their time as well. And I think when you're starting out in your career, or even when you're at a more senior level, knowing that you've got people to work with who inspire you and who you can constantly learn from and who are also supportive of your journey in law is very important, and it makes you feel like a valued team member who's making a meaningful contribution.
Yeah, I think that sense of mentorship is so important, especially to young lawyers, having someone to have their back and really guide them through the process, and the hands-on learning for sure. Speaking of, I guess, has there been a particular case or highlight that you would consider to be, a particularly good achievement in your career?
I think for me, working on the Czech Republic case when I was a junior lawyer, it was very challenging because we had a very small team, and it was the first time we worked on that type of case. But I worked really closely with some very senior lawyers. So we brought in Professor Vaughan Lowe as our international law expert. One of the partners I worked with was Audley Shepherd, who was a commercial arbitration lawyer. and public international law lawyer, but we also worked with Jeremy Carver, who's an international law lawyer. Watching that case go through 2 different arbitrations and then going to appeal or to be challenged in the Swedish Court of Appeal, so the Svea Court of Appeal, and working with the Swedish lawyers. All of that was amazing experience, an amazing diverse learning, different ways that different people worked, because obviously you're working with common law lawyers, public international lawyers on the one hand, then we worked with civil law lawyers, the Swedish civil law lawyers, so they have a different approach to certain things, and learning about that was just fascinating as a junior lawyer. It was hard work and a lot of long hours and a lot of long days, particularly during the hearings, but it was definitely worth it. And
I think on the commercial disputes front, so one of the matters that I was involved in that is memorable was a matter where we had a self-represented litigant on the other side who also did not speak English. So I think navigating through the court process in that matter was challenging and insightful as well, because you had to be conscious of not coming across as a bully in the courtroom, but also you can't advise the other side either because they're not your client. So you have to be very diplomatic in the way that you communicate with them. So what we actually did in that matter was we had the responsibility of communicating information about what happened during directions hearing to that other party, and we would send out communications in Mandarin as well as English, so that we did whatever we could to make sure they understood what was going on, although we couldn't advise them, and we'd constantly urge them, you should consider getting legal advice, you should consider getting representation. So I think that was an interesting experience. I don't think I've ever had that before in any other matter.
No, and it was really interesting to watch the judge explain to the self-represented litigant how the process works. And so once he started doing that, we already had a couple of paralegals in the room, but we sent messages back saying, please quick come up, it's only 2 minutes walk, come up to the court and watch the judge explain the process to the litigant. It was a really good opportunity for our paralegals who are university students to learn about the court process directly from the judge.
Yeah, of course, that would have been quite fascinating to listen to. And on the personal front, are there any personal highlights that you guys have had in your careers or lives?
I think obviously working in London is really an amazing opportunity. You meet lots of different people, you meet people from different cultures, as I already mentioned. You meet some of the big names in international arbitration or in other areas of law. You work for different clients from different cultures. So for me, that was just very exciting from a personal point of view as well as from a legal point of view. And obviously London's just a fantastic place to work. I think it went through some challenging times with Brexit, but now I think it's got through all of that. It's sort of back on track and is a really exciting place to work again. So if I was a young lawyer, I'd definitely be considering going back.
Maybe we'll end up there one day.
And I think for me, definitely going overseas and working in Malaysia was something that was beyond my wildest dreams. I never thought I'd leave Australia. Moving from Sydney to Canberra was a big deal for me. So it was just such an eye-opener because you're in a cultural melting pot with most of the people that you work with are actually from different parts of the world. So it was a very interesting experience, and I'm very grateful to have had that opportunity in my life.
Yeah, that's amazing.
I think travelling as a young lawyer is a really great idea, and now there's so many opportunities to travel. So it's not only London that are opportunities for Australian lawyers, there are plenty of places where we can work now. So I think definitely looking at travel is something that young lawyers should be doing. And even if it's only for a year or two, it's not just the interesting work that you get, but you make new friends, you get to travel on the weekends, and it just really opens up your mind, I think, to just different ways of working, different lives, and your perspective on life. You can't even imagine what it would have been like if you just stayed in Australia.
Yeah, that seems really interesting, and I think travel sounds like a dream for every kind of aspiring legal student out there, so that's really cool to hear as well. Now we'll kind of focus our attention on the international arbitration space in general. I know, Joe, you mentioned earlier kind of about tariffs and how in Australia there's been a growing number of arbitration disputes compared to before. So were there any other kind of industry trends that you guys had your eye on? What do you think might impact the space in the next 5 to 10 years?
I think AI is obviously the probably top of the list, and we're still learning how it's going to impact dispute resolution. Some of the larger firms I'm aware of, and when I've been to conferences overseas, they're using ChatGPT or a version of ChatGPT to assist them in preparing memos, for example. But obviously, any memo based on legal research using ChatGPT or any other form of AI needs to be double and triple checked to make sure the cases actually exist, as we've heard about in cases in the US and elsewhere. So it's interesting to see how some of those big firms are investing resources to use AI. So AI is one example. I think one other trend that's been a long-standing trend is making arbitration and the dispute resolution process more efficient. So on one aspect in Australia, we've been trying to make arbitration more consistent with international practice, which is more the efficient process I described before, with a procedural timetable all the way through, and trying to resolve the dispute within 12 to 15 months. That will, of course, depend on the issues in dispute, the complexity of it, and the value of the dispute. So it will vary from one dispute to another. But it's really important, I think, to continue that trend and try and focus arbitration practitioners or those doing arbitration on how can I make this dispute efficient, what type of process can I use for this type of dispute, and that's really important. Another area that is a bit of a trend is the constantly changing arbitration rules. So the arbitration institutions are all competing with each other to try to get their disputes referred to arbitration. And so the institutions are constantly updating their rules, and Akika is looking at updating their rules at the moment, but some of the other institutions have been updating their rules recently. So I think that trend is not something that happened 10, 20 years ago. It didn't happen so regularly, but now the institutions are updating their rules quite regularly to make sure they're dealing with all the different issues that are coming up in dispute resolution.
And I think the other thing we're seeing is that arbitration is actually being embraced by more niche areas of law. So off late, there have been a lot of space-related disputes being referred to arbitration. Sports arbitration's also really taken off. And also in the tech space as well, there is quite a bit of arbitration happening there as well.
Cryptocurrency and crypto disputes.
Blockchain disputes as well, yeah.
Wow, it's interesting to see how it's been developing and will continue developing. It's very interesting. And on that topic of there being even emerging areas for arbitration, what kind of career opportunities do you think are available for young lawyers who are interested in international arbitration at the moment? Obviously, we've touched on international opportunities or things like that, but I'd love to hear your insights on that.
So international arbitration is a really popular area for young lawyers, but there are many Australians, as I mentioned, practicing in this area. So I only mentioned a few of the UNSW alumni who were more of the trailblazers doing arbitration, but there are many people practicing arbitration in Australia, in Singapore, in London, New York, in many different countries. So career opportunities, I think, are quite diverse. You could practice in a dispute resolution team in a firm in Australia like HFW, or in one of the large firms. They have very large dispute resolution teams, and there are different partners there who are doing arbitration work. So working in a law firm is obviously one opportunity. You could also look at working in one of the arbitral institutions. So many of the arbitral institutions offer internships. So Akika offers internships, and you can look at working there for a 3-month period or a 6-month period. Or you could look at working in one of the larger institutions like the ICC, who have very large case teams in Paris, in Singapore, and in the other secretariats based around the world. And you could be one of the case managers, so working as counsel in one of the case management teams. And so that's another career opportunity to start as an arbitration lawyer. And a third area is to look at working for one of the arbitrators as you may end up working as a tribunal secretary, but in the beginning you might just be working as a researcher. So, for example, a couple of the arbitrators in Australia who are well known, Doug Jones and Michael Pryles, they take on researchers to assist them in their caseload and in managing their cases.
Yeah, there's a lot in there that is available for young law students. And I think a lot of people might think that firms are the only or the easiest pathway, but I think you're right, through tribunals, internships, that's also a very valuable experience, actually getting to be, I guess, in the middle of it. Nivi, do you have anything?
Also on the internship fronts, there are some, especially like in Europe, there are lots of law firms that look at hiring interns as, I think it's penultimate year or final year law students, and they're usually 3 to 6 month stints as well. So if you want foreign exposure, that's usually a good way to go as well. Most often than not, there's usually a language requirement there as well. So having language skills under your belt will be very beneficial. And just on the arbitral institution front, like I mentioned, I worked in an arbitral institution for a number of years. So a lot of the people that I worked with at the institution have left the institution, and they've all gone off to have wonderful careers in arbitration. So quite a few have gone back into practice. Some have set up their own firms. Some have gone into other arbitral institutions. And quite a few have also gone into academia as well. So that's always another option, going down the academic route.
Yeah, of course.
Yeah, it seems like there's a plethora of options and there's no real one set way, which is really cool to see in that kind of practice area as well. So kind of building on from that, obviously it's also clerkship season for a lot of our law students as well. So are there any steps or tips that you would recommend for a law student who's aspiring to get into the international arbitration space at both HFW and more generally as well?
Specifically for arbitration, I would start with making sure you've done the arbitration course if it's offered at your university. You might also want to consider being involved at university in different extracurricular things that relate to arbitration. So, for example, the VIS moot is often offered at most universities, or the Jessup moot, or one of the negotiation moots, mediation moots, that they're also going to be relevant for doing arbitration. And you might also want to think about doing an exchange program, and many of the exchange programs now are offered in Canada or in Europe, and at those universities there'll also be arbitration courses or courses relating to international commercial law or international business law or international trade, some area of law that might be relevant to helping you in an arbitration career.
And I think the other thing also with mooting is that in the lead up to the major moots, there are usually pre-moot competitions that you can get involved in as well. And what I've noticed is some of these pre-moot competitions, the first prize, especially if it's run by an institution, is a potential internship opportunity as well. So that's something to look into to break into arbitration. And the other thing is to get involved with young arbitration groups. So generally, it's very simple. You just sign up to their mailing list and you get emails about all the different activities that they have. A lot of them are virtual these days. You also have a lot of in-person events. So, organisations you can consider signing up to include obviously ICCF, IKEGA 45, Young ICA as well. They have a lot of initiatives as well. So, and pretty much all the arbitral institutions have a young member body. So any that you're interested in, feel free to sign up.
Yeah, thank you. I think that's some really good tangible advice for our students who, might just be considering what the first real step that they can make towards a career in arbitration is. And that takes us to actually our last question of the day. And I'd be curious also to what you guys have for this. But I guess looking back at your law school self, is there anything that you would like to tell them or any advice that you have for them, whether it's about your career progression or life as a lawyer or anything more personally even?
I think on career progression, I would really think about trying different areas that you want to practice in. So whether it's going to be arbitration or whether it's another area that you're interested in but you're not quite sure how to practice it, try different ways of practicing it. So I did that for a short time after uni before I started working in a law firm, and then made the decision to work in a law firm but then found arbitration. So think about how you want to practice. Do you want to practice in government? Do you want to practice in a law firm? Do you want to be an academic? Do you want to work for an NGO? There are so many different opportunities. I would also then think that once you've made that decision, then put together a new plan. So it's very easy once you start working in a law firm for time to pass and you get sucked into a case and you work very hard and then suddenly 5 years has passed and you've not really paid too much attention to what your plan is. So definitely think about like what's your plan going through a law firm and if that's your decision. Or for example, many people in Sydney decide they want to be a barrister, so they work in a law firm for 2 or 3 years, then they go to the bar. But even once you're at the bar, you've got to put together another plan as to how you're going to progress through that process. Or it may be that you try different opportunities later on. So another really good example is Professor Chester Brown, who's at Sydney University. I've known Chester since he attended the Model UN conference that I organised all those years ago. And he was still just at uni, and I had only just finished uni. He then did his, I think he did the BCL first at Oxford and a PhD. Then he came to work with us at Clifford Chance for a few years when I was still there. Then he went to the Foreign and Commonwealth Office for a few years, and then he came back here to be a professor at University of Sydney and also set up a barrister's practice. So he now acts as a barrister and as a professor so he does his classes, he does his academic work, but he also acts as counsel in many arbitration cases, particularly investment treaty cases. And I think that's obviously something he thought about as he went along as to how to plan his career. So really do think about it, and I would put together like a 5-year plan. The law firms will help you with this anyway nowadays. It's much more, law firms are much more focused on helping their junior lawyers come through the ranks. And so they'll help you put together a plan or help you think about it. But definitely put together a 5-year plan and review that regularly.
That's some great advice there. Nivi, do you have anything for your past self?
Well, I can admit that when I was in law school, I was really shy. So I think one thing I would tell myself is try to step outside your comfort zone and try new things, because you never know where the next opportunity might lie. And the other thing in terms of career planning, sometimes one of the most important things to keep in mind is to be patient and just believe in yourself. Getting your first break, whether it's in law or in arbitration, for some people it's a matter of luck and timing. It's just they're in the right place at the right time and they have that opportunity. For some people it takes a lot longer, but just because it takes a lot longer for you, don't sit there and feel like you've failed in your career. Setbacks are just a part of life and it'll help you grow. And a career in law at the end of the day is a journey, it's not a race. So you're not going to get any brownie points for, getting to partner level when you're 30, as opposed to when you're a bit older.
No, I think that's some very valuable advice, and I think a lot of law students might forget in the rat race to end up
ambitious.
To get like you said, like a partner position as soon as they can, or a really good clerkship as soon as they can.
Yeah, so life as a lawyer, I would add, it's a marathon.
Mm-hmm.
So don't forget it's a marathon, and that you will always have periods of time when you learn a lot quickly and periods of time where you learn less, or the type of work you're doing might be less interesting, a little bit more monotonous. Discovery is the usual example. But the importance of understanding the documents and the importance of doc review cannot be underestimated.
Mm-hmm.
It's documents and evidence that win cases. So you then realise when you're sitting with a barrister preparing a case and he's focusing on evidence and asking you or the team, where is a piece of evidence to support this statement? If you're the young lawyer that says, here it is, that will get you brownie points and also make you feel good because you know the case and you can be relied upon by the team and by the barrister.
I think sometimes you don't realise how much you're learning in the moment, but towards the end or in those moments you realise that all of the work is work at the end of the day.
Exactly, how important it is.
Yeah, that's very true.
Yeah, I think that holistic perspective is really, really good to see and really important as well.
I remember when I was in a hearing as a junior lawyer in the Czech case, I ended up sitting right in between all these senior lawyers, between the partner and the professor, because they didn't know the case like I did. And so I was the one passing them post-it notes saying, yeah, but what about this document will support what you're saying, or even though I wasn't doing the advocacy, I played a really important role and ended up sitting right at the front of the team, not down the back end of the table, because I was the one that knew the case. There weren't any other associates though, by the way.
Yeah, I think you find that the young lawyers, or even sometimes the paralegals, because you're doing the grunt work a lot of the time, you're often the most familiar with the intricacies because you're exposed to them the most often.
Yep, absolutely. I think as a young law student, it's really hard to think about what you want to do and not be influenced by others or influenced by society as to what you should do. So I started doing commerce law because I thought I should do that, and I quickly changed to arts law and went back to my history, which I really loved. Then when I studied public international law and the history of international law on my exchange program, I realised why I loved my history and how it connected to international law. And obviously in today's world and what's just happened over the weekend, to have some information about the history of these countries and why we're in this current state that we are can be really important just to understand world affairs. So follow what you're interested in, because you don't know where that path will take you, and you don't know what area of law you'll end up, or how you'll practice, or which firm you'll end up, or whether you'll end up in a in-house in a company doing what you love. But when I look back at the law students I was at uni with, there are not many who are barristers or lawyers or partners in law firms. There are some, of course, but there are many who are doing other interesting things. So some of them have worked at Macquarie Bank, some of them have worked in-house for a long time, and some of them are doing a completely different area in their career. They're not doing law at all, but law will help them get there. So just think about what you want to do and what interests you, and don't be too influenced by others.
I think the other thing is don't be afraid to have a very diverse skill set. I think sometimes people just look at the traditional route to getting into law and getting into a law firm as, their ultimate goal, but there are different ways that you can have a thriving legal career. It doesn't necessarily have to be at a law firm, and all that other experience that you gain along the way will be valuable, both in terms of developing interpersonal relationships and also just succeeding generally within the field as well. So don't underestimate the importance of embracing diversity.
And one more tip for summer clerkship applications is to show the firms how diverse you are. So show the firms that you're obviously studying and working hard at uni, but you're doing extracurricular activities which might be in or outside university. That's something I always look for when I'm interviewing students. Whether you're involved in the Law Society and doing podcasts like this, or whether you're involved outside your university, you might be heavily involved in sport or a drama, theatre, or something completely different. Also look at what type of work experience you can get. So work experience in the law is obviously important, and it's easier to get paralegal jobs nowadays than it was in the past. So working in a law firm will help, but it's not the be-all and end-all. If you've not got a paralegal job, that doesn't necessarily matter. Something else I always look for is someone who has worked. And I don't care if you've worked in Coles or Kmart or McDonald's. I just want to see someone who's worked before, who's been in the workforce, who's had to work in a team, and who's had to show that they can manage their study life and their work life. So whether it's part-time work and full-time study, or whether it's part-time study and full-time work. That's hard to manage time and priorities. Being able to manage your time, be proactive in that process is obviously incredibly important, because we see that when people come on to be lawyers, they're the ones who do well. The ones who are used to managing their time are better at managing their time on task within the firm, and also managing their time with getting the work done, meeting their priorities, meeting their deadlines, and also managing to leave and go and finish your studies or whatever you have to do that day or that week.
Mm-hmm. Yeah, that's really good advice, and I think there's no one type of lawyer as well, which is really important as well for a lot of students out there. So thank you for your insights. So yeah, I guess we'll wrap things up. So thank you guys so much for meeting with us today and chatting about your work in international arbitration and your career journeys. I certainly learned a lot. I'm sure our audience as well will have learned a lot of insights about just being a lawyer in general, and also your journeys at HFW. And so we really appreciate having you guys on the podcast and offering those insights as well.
Well, thank you very much for having us. We enjoyed it a lot. Thank you.
All right. Thank you for listening to Insights by UNSW Law Society. If you enjoyed this episode, continue to listen to our podcast so you don't miss out on any further episodes.